Hi everyone, I'm Carol Williams with Williams Immigration, and on this edition of Beyond the Soundbite, this glorious Monday morning, we are going to talk about a few things. As you know, I like to talk about all things U.S. immigration that have happened generally in the previous week, but sometimes we know things linger in the immigration service. So I like to keep you updated. So sometimes we talk about things that are outside of the week. The first thing I want to talk about, because y'all know I'd like to dive right on in, is the current H-1B cap season breakdown. I have gotten a lot of questions about how many registrations were received, how many lottery registrations were selected, and it does take the Immigration Service a little while to get us that information, but now that they have it, I am passing it on to you. So overall, they received just over 780,000 registrations. Of that 700, just over 780,000, almost 760,000 of those were eligible registrations. And by eligible, I mean eligible to actually be in the cap, to be in the lottery. Registrations are kicked out of the eligibility and kicked out of the lottery and not a part of the lottery if they do not follow the rules of the lottery. So one big reason why a registration would have been entered but not part of the lottery is if the same company entered the same individual multiple times. In a sense, trying to game the system and get that individual more opportunity to be chosen. So that is the difference between those registrations that were eligible and those registrations that were just sent in. So of the eligible registrations, 110,791 were selected. So those applications are now in the process, or those registrations, I should say, are now in the process of being prepared and filed with the Immigration Service. And as a reminder, if you were selected in the lottery, you have until June 30th to file that application. So if you need assistance on filing your H-1B CAPS subject application, feel free to give our office a call. We are happy to help you with that. We can be reached at 954-903-1337. The second thing I want to talk to you all about this morning is that the Department of State has suspended visa services in the embassy in Sudan. So it has suspended its operations, which means all immigrant for green card applications and interviews are canceled until further notice, as are all diversity visa interviews. Those are also canceled until further notice. Now, if you had planned to apply for a non-immigrant visa through the consulate, through the embassy in Sudan, you may not do so, but you may apply in any other country in which you are physically present or where you find an available appointment. So let me repeat that for y'all. The embassy in Sudan has suspended its operations, which means all immigrant/green card interviews and diversity interviews have been canceled until further notice. If you have an interview, or if you are planning to schedule an interview for a non-immigrant visa, you cannot do so at the consulate in Sudan, but you can go to any country which you are physically present or where you can get an appointment. So I will keep you updated and certainly let you know as that embassy in Sudan opens up and as they start processing applications again. We will let you know and keep you updated here Monday morning. The Customs and Border Protection, they have a proposed rule that they have released. They are proposing to add a third gender marker of X to their Trusted Traveler Program applications. This gender marker of X they want to include this so that they are inclusive of individuals who are non-binary, intersex and or gender non-conforming, for which simply checking male or female may not work for them. So the impacted applications would be the Sentry application, the FAST application, the Global Entry application, as well as the US APEC, that's APEC, Business Travel Card Program. So CBP has published that rule. They have provided a 30-day notice and comment period, which will end on May 30th, 2023, obviously of this year. So if you have comments that you wish to submit to CBP, feel free to do that. And again, they are proposing that they add a third gender marker of X to their Trusted Traveler Program applications for individuals that are non-binary, intersex, and or gender non-conforming. The next thing I want to talk about is travel and COVID and the vaccine requirement. And we have seen those rules change often over the past couple of years with COVID. And so now the White House has announced that the COVID-19 vaccine requirement for international airline travel will end on May 11th of this year. So no longer requiring the COVID vaccination in order to travel internationally. And that will end on May 11th, 2023. Also on May 11, 2023, we will no longer require non-US citizen travelers entering the United States via our land ports or ferry terminals to have the COVID-19 vaccination and to show proof of that. So again, if you have any questions about whether or not you can hop on a plane and come into the US and how that relates with the COVID-19 vaccination, please let our office know. We are happy to help you understand the current rules. Employers, that's my next topic. We have been talking about the I-9 flexibilities and being able to review I-9s remotely for the past couple of years since COVID began in 2020. We have always known that that was a temporary measure and that it was going to come to an end. Well, now we know when it ends. It is due to sunset or end on July 31st of this year. So July 31st, 2023 is when the immigration agency is sunsetting that rule. So ICE has announced that employers will have 30 days to reach compliance after that rule sunsets on July 31st. So employers, we super encourage you, if you have not already started, to pull in all of your employees that you did the virtual document review for their I-9s and now do them in person. So that means looking at the physical documents in person. If you are not sure how to make that happen, or you need a plan, or you're confused by this, please let my office know. We are happy to walk you through that and happy to help you set up a plan if necessary. But again, you are only going to, that rule sunsets July 31st, and the immigration, ICE is giving employers 30 days past that to reach compliance. So I, of course, would recommend that we reach compliance before July 31st. But that is, that date is going to come up fast for us. So again, if you have any questions about the 30-day sunset, please let us know. The last thing I wanted to talk to y'all about is still I-9 related, is that we have states that are super into technology, and they have now started to issue digital or mobile driver's licenses. Some of these driver's licenses actually can sit within the Apple Wallet ecosystem. And so those states are currently Arizona, Colorado, and Maryland. However, while technology is fabulous, USCIS has not explicitly said that they will accept a digital driver's license for a List B I-9 document. So for now, until USCIS gives us the okay, my recommendation is to be very, very conservative and not accept these digital driver's licenses. What you don't want to do is sort of unknowingly be out of compliance with the I-9 rules. Okay. So keep that in mind if you are looking at documents, if you are responsible for the I-9s in your organization and you are presented with a digital driver's license, specifically from Arizona, Colorado, and Maryland. The Immigration Service just simply hasn't caught up to that yet. And the very last thing I want to talk about is another national interest waiver tip. And as you know, the national interest waiver is a green card category where you must show that your proposed endeavor has substantial merit and national importance to the United States, that you are well positioned to advance your proposed endeavor, and that on balance, it's really beneficial to the United States to waive the requirements of a job offer, a sponsor, and the labor certification requirements. This is a popular green card category because individuals can self-sponsor, so they do not need a sponsoring employer. A question I get all the time about national interest waiver applications is how many support letters do we need? What's the magical number? Well, I'm here to tell you there is no magical number. I always tell my clients the more the merrier. The more individuals in your industry that you can get to write a letter on your behalf, showing that what you do is of substantial merit, and that you are a superstar within your industry and that you're doing really great things and that you are a change maker within your industry. I can never have enough of those letters when we are preparing a national interest waiver application for someone. So, as frustrating as it may be, there is no hard and fast rule as to how many support letters you need. There is no magic number that automatically guarantees an approval. It's really the quality of the letters, and how they are written, and what your colleagues in your industry have to say about you. So keep that in mind. There is no magical number, but we are certainly able to help you kind of walk through, and think about who within your industry and who within your circle would be great to write letters for you and on your behalf. So that is all I have this morning for our another Monday morning edition of Beyond the Soundbite, where again, we talk about all things U.S. immigration. So if you have any questions, please feel free to reach out. I can be reached at the office at 954-903-1337. Have a wonderful Monday.